Jared Sullivan, 25M42624 M439. And good morning. Can you tell me your name, please?
Jared Mark of the family Sullivan.
People, what is the outcome of your conversation, Mr. Sullivan?
Your Honor, Mr. Sullivan indicated to me that these are likely going to become trial cases. I do have a note in the file that Mr. Sullivan filed a discovery demand, but has not yet come to our office or requested that discovery in any way. So I did inform him that he can go upstairs to our office and request that discovery. I also offered to provide the Larimer County website where you can make a discovery request, but he did not want that website written down for him. So I've instructed him up to the second floor to request that discovery after this court date.
Okay. Mr. Sullivan, what are you asking the court to do today?
Well, I'd push for another dismissal based on failure to state a claim.
Mr. Your motion to dismiss is settled, and I will no longer be considering any more motions based on the grounds you previously asserted.
Well, and your response to that is just adding claims on the record that haven't been brought up by either parties. And it leaves the appearance that you're acting outside of the bounds of your duties as an independent third party.
You are asking me to review motions and issues that I reviewed, I think, last year and already acted on, and I'm not doing that again.
Do you have an oath to the Constitution on record, sir?
Beg your pardon?
Do you have an oath to the Constitution on record?
We've discussed this, and so we're going to move on. You are choosing to...
Do you have an oath of office on record to the Constitution, sir?
Sir, you may not interrupt me. I'm going to go through... You are choosing to represent yourself, is that correct?
Yep.
Then I have to ask you some questions. And I think I've asked you this before, but we'll go over it again. Are you currently under the influence of any drugs, medication, or alcohol that would affect your understanding of these proceedings?
No.
Do you understand that you have the right to be represented by an attorney throughout these proceedings?
Yes.
Do you understand that if you cannot afford an attorney, that an attorney can be provided to you at no charge to you if you qualify financially for that service?
Yeah, we've already done that.
I know, but do you understand that?
Yeah.
And do you understand that I would appoint counsel to represent you?
All right, guys, let's break this down. Right from the start, Sullivan sets the tone, and it's not a good one. He refuses help with discovery, rehashes arguments already denied, and even questions a judge's authority. That's not strategy. That's resistance without understanding, and it immediately puts him on the back foot.
If you wanted an attorney to represent you, provided you meet that financial eligibility requirement. Do you understand that?
Yes.
Do you have any legal training?
No.
How far have you got in school?
Some college?
Do you understand that the criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and presenting and representing your defense?
No, I don't understand that because I haven't seen evidence of it.
Because what?
I haven't seen evidence of that, especially through the attorney that I was provided that offered ineffective assistance of counsel.
Well, all I'm asking is, do you understand that the criminal, I'm not asking you about the specifics of the case. Generally, do you understand that criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and presenting your defense?
In theory, yes.
Do you understand that you will be held to the same rules and laws as an attorney would, even though you do not have the same training and qualifications of an attorney?
No.
You don't understand that? I will explain it. You will be held to the same rules and laws as an attorney, even though you don't have the same training and qualifications. For example, the district attorney just discussed discovery. An attorney who is trained and qualified knows that they have to make a request to the district attorney to disclose the discovery. The district attorney doesn't just automatically provide it. Once they get that request, they will provide what they're required to provide under Rule 16 of the Colorado Rules of Criminal Procedure. The district attorney has said that you have not made that request yet. So that would be an example. So if you came back at trial and told me they never gave you discovery, then I would hold you to the same rules and laws as an attorney would be held to, which is that if you didn't request it, then that's on you, not them. So that's an example of you being held to the same rules and laws as an attorney would, even though you do not have the same training and qualifications as an attorney. So do you understand that?
I don't, because my attorney, the ineffective assistance of counsel that was provided by the court, had already requested that discovery, and I keep filing the same discovery requests because they refuse to release it. Exculpatory evidence.
So I'm not, again, asking you, I just used an example from your case to illustrate the general idea. The general idea is, do you understand you will be held to the same rules and laws as an attorney would, even though you do not have the same training and qualifications as an attorney?
As things move forward, the court stays structured while Sullivan stays defiant. The judge walks him through his rights and the complexity of the law, but he pushes back on even basic concepts. When someone refuses to acknowledge the rules, they're not preparing for court. They're setting themselves up to clash with it.
Sure.
All right, court will find that decision is knowingly and voluntarily made. So in 25M426, what is your plea to obstructing a peace officer, guilty or, well, actually, I should probably have the people recite the last offer communicated to Mr. Sullivan on one or both of these cases if it's a global offer.
Yes, Your Honor. In 24M439, the last offer was to plead to original count 1, no proof of insurance with a $500 fine and 4 points against the DMV. In 25M426, the last offer was to plead guilty to original count 1, obstructing with 6 months of unsupervised probation and ISAE discovering better choices class within 5 months, 16 hours of UPS within 5 months, and to remain law-abiding. Both of those offers are now revoked.
Well, we'll get there in a minute. So in 24M439, if the plea of guilty is to count 1, does that, am I correct in inferring the offer contemplates dismissal of the remaining counts?
Yes, Your Honor, I apologize.
Mr. Sullivan, did you hear what the district attorney just communicated?
Yes.
If you enter a plea of not guilty, all of you will be communicating to the district attorney you would not accept that offer. You'd be communicating, and the district attorney is free to withdraw it. And if they choose to withdraw it, they may choose not to put any new proposals on the table for a resolution of either case, which may leave the trial that I set as a result of your not guilty plea as being the only way to resolve the cases. Do you have any questions about that?
No.
So in 25M426, what is your plea, guilty or not guilty?
I do not consent to enter any plea on my behalf. I do not comprehend or understand how to enter a plea, as there is no injured party in this matter and no evidence of any contractual obligation requiring performance to follow the corporate state of Colorado statutes, codes, ordinances, and rules that are merely policies of the corporation acting as government under the color of law outside the bounds of the constitutions of the United States and the state of Colorado.
All right, so it sounds like you're refusing to enter a plea, is that correct?
Yes, sir.
Then the court will enter a not guilty plea on your behalf. On 24M439 to count 1, driving without insurance, count 2, obstructing a peace officer, count 3, driver's license refusal to display it, count 4, fictitious plate. What are your pleas, guilty or not guilty?
I do not consent to enter any plea on my behalf. I do not comprehend or understand how to enter a plea, as there is no injured party in this matter and no evidence of any contractual obligation requiring performance to follow the corporate state of Colorado statutes, codes, ordinances, and rules that are merely policies of the corporation acting as government under the color of law outside the bounds of the Constitution of the United States and Colorado State.
So am I also correct in inferring you are refusing to enter a plea in 24M439 as well?
Yes, sir.
Court will enter a not guilty plea on Mr. Sullivan's behalf. Are you requesting a trial to...
Now the court shifts into plea discussions. Offers are clearly explained, consequences laid out, but Sullivan refuses to enter a plea entirely. That forces the judge to enter a not guilty plea on his behalf. At that moment, he loses procedural control while thinking he's asserting it.
The court or a trial to a jury on these two cases.
I'm demanding a trial by jury.
All right.
And are you planning on scheduling those back-to-back, Judge? Was that my understanding?
I beg your pardon?
Are these trials scheduled back-to-back?
Right. So if one will go and the other one will get continued.
Okay.
And Mr. Sullivan, are you ready to proceed to trial?
No, I don't believe so. Well, maybe on the 439 case.
Yes,
I know that.
yes or no answer to know how to proceed next.
Well, I was prepared. I didn't know we were splitting them back up.
Beg pardon?
I didn't know that we were splitting them back up.
Why we're splitting them back up?
Well, they're scheduled for the same day for this trial next week.
Right. They wouldn't both go to trial at the same time. They would, one or the other would go.
Okay. Well, then, yeah, I can do 439.
All right.
And that 426, I'm still waiting for discovery and disclosure of witness names.
Then I will note that the deadline for resolution is February 23rd at 12:30 p.m. Will you be requesting the new reasonable doubt instruction?
Yes, sir.
The new reasonable doubt instruction reads as follows. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If you are firmly convinced of the defendant's guilt, then the prosecution has proven the crime charged beyond a reasonable doubt. But if you think there is a real possibility that the defendant is not guilty, then the prosecution has failed to prove the crime charged beyond a reasonable doubt. And a reasonable doubt can be based on the evidence presented or the lack of evidence presented. New reasonable doubt. Are you going to have an objection to me reading that reasonable doubt instruction to the jury?
Pardon me?
Yes.
I'm fine with that. That's fair enough.
People, how long are you asking for voir dire?
It's 10 minutes, Your Honor.
Mr. Sullivan, how long are you asking for voir dire?
For what?
Voir dire.
I don't know what that is. What's quite done?
It's the process where you ask the jury questions to find out ahead of the jury being selected whether or not the people who are called to serve as jurors can be fair and impartial.
Is that between individuals or in lump?
Mr. Sullivan, you may recall when I gave you an advisement that said that if you're choosing to represent yourself, you need to understand that you will be held to the same rules and laws as an attorney would, even though you don't have the same training and experience as an attorney. So I'm not planning, I'm really not able to coach you through this process. I'm expecting you to come to court already having this knowledge of what will be happening at a jury trial.
Then comes the contradiction. He demands a jury trial, but isn't even sure he's ready to proceed. The judge presses for clarity, and Sullivan hesitates, backtracks, and guesses. Big legal demands with zero preparation. It's a mismatch that becomes impossible to ignore.
Well, all I can do is guess at this point.
Let me put it this way. We will not slow the trial moving forward because you are not knowing or understanding things you should know or understand ahead of time. For example, voir dire will be 15 minutes in length, regardless of how long, once you have figured out what voir dire is, how long you want to use on voir dire. It'll be 15 minutes in length. How long are the people requesting for opening statements?
5 minutes, Your Honor.
Mr. Sullivan, is 5 minutes going to be long enough for you to make your opening statement?
And maybe go 10.
The court will allow 5 minutes for opening statement because what needs to be, what is stated during opening statement is a recitation of facts. It's not argument or commentary on the law. And 5 minutes should be adequate to cover that. People, how long are you asking for closing?
10 minutes, Your Honor.
And sir, how long do you think you need to close?
I imagine that'll work.
Beg your pardon?
I imagine, well, clearly you're just going to say 10 minutes, so I'm going to say 20 minutes. Because I'd rather have extra time, whether I need it or not,
Well, I will allow
than
15
getting cut
minutes.
short.
I will allow 15 minutes for closing because there are 4 counts. Those counts do not all rely on the same evidence. So there may need to be a little bit more argument regarding how the facts fit or don't fit with those elements. Will any witnesses need special accommodations, people?
No.
Are you planning on using the courtroom technology?
Yes, Your Honor.
Mr. Sullivan, were you planning on using your computer to publish exhibits to the jury?
To my knowledge, that's the only way to do it, is if I bring my own
I
equipment.
don't understand what you're saying.
To my knowledge, that's the only way to do it, is if I bring my own equipment, right?
Well, no, you can have paper copies and share them with the jury by having them look at paper. The reason why I'm asking, if you're planning on publishing with a computer, then you will be using the courtroom technology to accomplish that. And again, it's a situation where you need to be ready to have that going, because I'm not going to wait to troubleshoot issues. We won't be troubleshooting issues in front of the jury.
Okay.
I don't know if I can ask about exhibits, conferring on exhibits, because I don't have an exhibit list.
I haven't been provided any either.
All right, Your Honor. As I said, I will immediately after leaving here, I will provide that and also get some good contact information from Mr. Sullivan so he and I can confer so that we can make sure that there are no issues going into the trial.
All right. Do you have exhibits that you intend to admit?
Just body-worn camera, Your Honor.
I'm sorry, I'm speaking to Mr. Sullivan.
Oh, yeah, I've got an exhibit list turned in.
Right, but the question is more directed. Well, you answered my question, so I'm going to ask the next question, which is, do you know how to admit exhibits?
Probably not. As far as getting them to the clerk, or?
No, getting them in front of a jury.
Oh, no.
Asking me whether or not I will allow the exhibits you have to be in front of a jury, to see, to allow the jury to see and consider the exhibits as evidence.
No, I don't.
Okay. Again, that's something you are expected to have ready. You are expected to have.
Once the discussion turns to trial mechanics, things unravel fast. He doesn't understand jury selection, opening statements, or how evidence works. The judge makes it clear, no coaching, no delays. If you represent yourself, you're expected to perform like a professional, not learn on the fly.
You are expected to be ready to do. And so what I'm not going to do is coach you through the process. And what I'm not going to do is wait for you to figure out how to admit it in real time. I'm telling you this now so that you are not surprised when we get to the trial. I don't know if there's anything else I need to take up. This trial is second in priority, so if Mr. Bangs is ready to proceed to trial, this trial will be continued. If Mr. Bangs is not ready for trial for any reason, then this trial will proceed. With regard to 25M426, I granted the people's request to add count 2, speeding 20 to 24 miles over posted speed limit. Class A traffic infraction, count 3, failure to provide proof of insurance, a class 1 traffic misdemeanor. And count 4, displaying fictitious or altered license plates, a class 2 traffic misdemeanor. All also alleged to have occurred on April 7th, 2025. What is your plea to those 3 newish counts, guilty or not guilty?
I don't consent to enter a plea. I was never served with any of the documentation for that motion.
So the court would first note that it's your responsibility, sir, to make sure that we have current contact information. So the information that when we take an action on this case, you're notified about it.
Are you insinuating that my contact information has changed?
I granted this motion on November 12th. Did you receive a copy of my order?
Yeah, I did, and I objected to it, and
Then and did you get a copy of the motion before ahead of my order granting it?
no, I just got the order granting it. I didn't receive anything.
So do the people have current contact information for you?
It hasn't changed.
What?
It hasn't, my contact information hasn't changed. My mail continues to go to the same address. That is the only thing that I have noticed.
So people, it appears you have the correct email address, and I don't know if you've been emailing copies of what you've been filing, but you are not sending information to the correct mail address. You have it as Fort Collins. It's not Fort Collins, it's Loveland.
Understood, Your Honor. I'll make sure that we update that in our system. I do believe, though, that through e-filing, he should be getting automatic mail notifications.
What now?
Should he not be getting mail notifications through e-filing? No? Okay. I'll just double check to make sure that we have the correct address on file so we can ensure that that is getting sent to him. Also make sure that I just email him copies of everything that's been filed in the case thus far. And as I stated earlier, I'll get in touch, I'll speak with Mr. Sullivan right now to get some updated contact information so we can confer about everything regarding both of these cases.
Court enters a not guilty plea on Mr. Sullivan's behalf, and on counts 2 through 4 in 25M426. 25M426, the request to continue is granted. Anything else we would need to take up for Mr. Sullivan?
Just to ensure that we focus on the actual law as it stands and not some of the superfluous materials which have come up throughout the case.
I intend to keep a tight lid on this case may be about and what it may not be about, which, Mr. Sullivan, I think the best information you should take away from that answer is if I make a decision about an argument or a piece of evidence that you disagree with, you are free to object. You are not free to argue with me about it. If I sustain an objection to a piece of evidence or an argument that you make, you may not try again to get the same piece of evidence or argument in front of the jury. I shouldn't have to sustain an objection more than once to a particular piece of evidence or a particular argument. I'm expecting full cooperation with that, and if you believe I'm mistaken, you are free to object, and if I overrule your objection, your remedy is not to either keep arguing with me about it or to keep making the same objection over and over again. It is to wait to see the outcome of the trial, and if the outcome of the trial is a conviction, then you may appeal any error that you think I might have made. Do you have any questions about that?
No, I've made it clear that I don't feel like there is a fair trial involved, so I'm just...
By the end, the gap between confidence and competence is fully exposed. He admits he doesn't know how to admit evidence, struggles with basic procedure, and still claims the system isn't fair. That mindset locks in failure before trial even begins. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.